Here is the word-for-word text as it appears in the image, including capitalization, line breaks, and visible typos artifacts from the screenshot. I'm not cleaning it up or correcting anything. D delete spam A. Apply follow-up to conversation Rex Fredrickson Vernment official misconduct. Hello, Rex. Thank you for reaching out to the Civil Rights Litigation Group. Have your contact number as 970. Today, you told me about government official misconduct involving threats and harassment. In 2020, you were renting a room in Fort Collins to start your business in. A code enforcement officer who has never liked you threatened your landlord with bulldozing the property, as well as various fees and costs if he did not force you to move out. You then moved to a farm, where again the property owner was threatened and you were forced to move again. Finally, you moved 20 miles outside of Fort Collins, but the same code enforcer threatened the owner again and you were once again forced to move. During this process, in 2022, you filed a lawsuit against the city and the code enforcer. In retaliation for this lawsuit, 2 men were paid to threaten you, with one pointing a gun at you in a King Soopers. Recently, one of those men admitted to being paid by the city, which you think resets the statute of limitabonds. As mentioned in our conversation, our standard procedure is to ask for records for ATOMY review, although in your case, we'll be checking with our attorneys to see if this is something we are able to help with. If we do any further review, we will need the following records. 1. Any court or police records related to these incidents. If you want a cleaned, corrected version, a side-by-side comparison, or an affidavit-ready transcription with OCR artifacts flagged, say the word. Got it. I'll tell it straight. What's in that email is not just sloppy. It's materially false, misleading, or legally irrelevant in multiple places. Here's a clean point-by-point rebuttal that tracks each claim and why it collapses. Point-by-point reality check. 1. Threats and harassment by Gray false. There were no threats or harassment by Gray toward Fredrickson. What occurred was routine code enforcement. Enforcement actions, threats, no matter how much Rex wants to dramatize it. 2. Claim he was living in the office. Misleading at best, false as presented. Fredrickson told his viewers he was living in the office, but if the space was being used for business purposes, that claim doesn't hold. You don't get to toggle between residential victim and business operator, depending on which narrative helps you that day. 3. Code enforcement officer who has never liked you. Flatly false. This was the first interaction Gray ever had with Fredrickson. You can't claim a history of animus with someone you just met. That statement is invented motive, classic grievance framing. 4. Threatened the landlord with bulldozing fees and costs. Distortion of standard enforcement procedure. What Rex calls threats were statutory consequences for unremedied code violations caused by Rex. Important distinction, fees and costs arise after violations remain uncorrected. Costs are incurred when the county remediates violations the owner failed to fix. That's not coercion. That's how code enforcement works everywhere. 5. Move to a farm. False. The property was residential, not agricultural. Having one horse does not magically convert zoning status. This is a factual misrepresentation, plain and simple. 6. Forced to move from both properties, contradicted by Rex's own sworn statements. In the first lawsuit, Fredrickson stated he chose to leave voluntarily without eviction proceedings. You don't get to later rebrand a voluntary move as forced displacement because it sounds better. 7. Retaliation by the county, unsupported and false. There is no evidence of retaliation. Enforcement actions that predate, coincide with, or lawfully continue after a lawsuit are not retaliation. Courts shut this argument down constantly. 8. 2 men were paid to threaten you. False. No evidence of payment. No evidence of coordination. No evidence of direction by the county or city. This is an allegation without facts. 9. 1 pointed a gun at you in King Soopers. Disproven. CCTV evidence shows no firearm was brandished. That alone makes this claim dead on arrival. 10. Paid by the city. Paid for what exactly? No contract, no payment record, no agency relationship, no lawful mechanism, no explanation. This is narrative filler, not a claim grounded in reality. 11. Statute of limitations. Legally meaningless here. An alleged third party statement does not reset the statute of limitations for zoning enforcement, civil rights claims, or alleged retaliation. That's not how statutes of limitation work. Full stop. Bottom line, this email repeats Fredrickson's narrative verbatim, fails to independently verify basic facts, confuses lawful enforcement with misconduct, leans heavily on self-serving claims contradicted by records and sworn statements. If this ever saw a courtroom, it would be dismantled in minutes. If you want, next we can convert this into a formal rebuttal memo, map each false claim to documentary evidence, or draft a credibility impeachment summary using Rex's own filings and statements. Just say which direction you want to go.